The first 10 amendments to our Constitution protect certain rights that are considered so fundamental that they are beyond reproach. Among them, freedom of speech, exercise of religion, and due process if accused of a crime. But for most of our country's history, those rights weren't ironclad. In fact, state governments weren't bound to them at all. Let's talk about why. Hi, I'm John with Prima Facie, and today we're going to be starting a series on Incorporation Doctrine, how the promises of the Bill of Rights began as empty ones, but slowly came into force, extending across the United States. We'll start at the beginning. The Constitution was drafted in 1787, and over the course of the following 2 years, the requisite 9 of 13 states ratified the document, bringing it into legal force. This wasn't without significant controversy, though. Many prominent figures argued that a centralized federal government, the Union itself, would lead to the same sort of overreach that they had just fought to avoid. To address those concerns, a number of states, among them New York, Virginia, and Massachusetts, attached a list of requested amendments to be passed after the Constitution was ratified. After ratification, Congress convened for the first time in 1789, and spearheaded by the principal drafter of the Constitution, James Madison, a consolidation of those recommendations was sought to cement the Republic. Out of the 12 amendments that Congress proposed to the state legislatures, 10 were ratified, primarily those enumerating personal rights and liberties that were to be beyond the reach of centralized government. Today, we often like to think of the Bill of Rights as enshrining our fundamental privileges as American citizens, but the language isn't that simple. For example, the First Amendment states that Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. By using the word Congress specifically at the beginning, this amendment appears to say that only the federal government and not the government of the states is restricted by this amendment. The rest of the amendments make no clarification on this point whatsoever. The Fourth Amendment, for example, states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures shall not be violated. When we look to the legislative process that brought about the Bill of Rights, the picture becomes a bit clearer. In his initial address proposing his versions of the proposed amendments, Madison states as follows: "I wish also, in revising the Constitution, to add that no state shall violate the equal right of conscience, freedom of the press, or trial by jury in criminal cases, because it is proper that every government should be disarmed of powers which trench upon those particular rights." Such a provision never made it into the Constitution, but Madison's words still are worth noting because they are representative of a widely held belief at the time that has since fallen out of favor in modern jurisprudence. Madison states that every government should be disarmed of powers which infringe upon those rights in the Bill of Rights. According to this, what we might call the natural law viewpoint, no just government could infringe upon those privileges. In effect, the Constitution was just recognizing them rather than actually promulgating a new set of privileges. The natural law viewpoint drew heavily from an Enlightenment and British common law tradition that held sacrosanct the security of every citizen under a just government to life, liberty, and property. For example, as John Locke states in his second treatise on government, the state of nature has a law of nature to govern it, that being all equal and independent, no one ought to harm another in his life, health, liberty, or possessions. Some feared that in enumerating those rights on paper, it might actually diminish them and put their sanctity at risk. The double-edged nature of the Bill of Rights, as enumerating certain inviolable rights, but in doing so opening them up to potential breach, was outlined by Alexander Hamilton in Federalist No. 84. I go further and affirm that bills of rights, in the sense and to the extent in which they are contended for, are not only unnecessary in the proposed Constitution, but would even be dangerous. They would contain various exceptions to powers not granted, and on this very account would afford a colorable pretext to claim more than were granted. For why declare that things shall not be done when there is no power to do? This viewpoint didn't die with the passage of the Bill of Rights, though. In the early Republic, in the decades that followed, full of debates and disputes needing resolution, many lawyers and judges continued to rely on the British common law and natural law tradition for their claims. In 1831, for example, the Ohio State Supreme Court, in a ruling for an owner whose land was being appropriated for the construction of a canal, stated as follows: We cannot presume that the legislature would be unmindful of the Constitution of the United States, which declares that property shall not be taken for public use without just compensation, Amendment 5, of that fundamental principle of which our constitutions are only declarative, that when the government takes private property for public use, full compensation shall be made to the owner. The laws of nations require it. From the viewpoint of the Ohio State Supreme Court, in the Fifth Amendment, the Constitution didn't actually institute something new. It just recognized and articulated a pre-existing natural and fundamental right. This issue of the source of the rights enumerated in the Bill of Rights and whether or not they extended to state governments remained an open question. That is, until the early 1830s, when a small case from Maryland about the right of two wharf owners to compensation worked its way up the chain to the Supreme Court. In the early 1800s, the city of Baltimore was faced with a number of necessary improvements. The port city, flanked by hills that sent streams running through the streets, sought to divert a particularly problematic stream by grading two streets, Ann Street and Washington Street. That way, the water would run cleanly down one street into the bay. While it worked well for the city, this was devastating to two joint owners of a wharf in the bay, Irish immigrant John Barron Jr. and his business partner John Craig. The two had saved up for years to purchase a $25,000 wharf, about $500,000 in today's dollars, that had that price tag because it was situated in deep water, so it can serve as a loading and unloading dock to large merchant ships. In diverting the stream, the city sent with it all the muck and grime and dirt from the hills and the city, so much so that it raised the level of the seafloor under their wharf, rendering it too shallow for mercantile ships to dock. Because of this, the two sued the city. Or rather, their financier and friend Luke Tiernan sued the city on their behalf after they both went under financially. In keeping with the common law and natural law tradition, neither the plaintiff nor the defense argued about the propriety of the suit under the Fifth Amendment to the U.S. Constitution, or even under the Maryland State Constitution. Rather, the plaintiff pursued a claim of negligence under British common law, arguing that since the city had other options to divert the stream, they were liable for the damage done to the wharf. The city, for their part, argued under the common law principle of damnum obseque injuria, which stated that since the city was operating lawfully to correct a public nuisance, they weren't liable for any damage done to the wharf. Ultimately, the plaintiff wharf owners were awarded $4,500 by the jury. But that decision was reversed by the Maryland State Court of Appeals, who ruled that the city had acted properly in exercising its ability to make public improvements. The plaintiff appealed the case to the Supreme Court, still led at that time by Chief Justice John Marshall, and the court heard oral arguments in the case in February of 1833, still located at that time in the basement of the Capitol building. At the beginning of his argument, Marshall instructed plaintiff counsel Charles Mayer to confine his argument solely to the question of whether or not the court had jurisdiction to overturn the Maryland Appellate Court's ruling under the Fifth Amendment to the Constitution. At the conclusion of Mayer's argument, Marshall ended the proceedings entirely, without even a word from the city. Less than a week later, the court released its decision, now immortalized as Barron v. Baltimore. Marshall delivered the unanimous opinion of the court, rejecting the plaintiff's argument and stating that the court did not have jurisdiction in the case because the Bill of Rights and the Fifth Amendment did not apply to state governments. On that subject, Marshall stated that it was a question of great importance, but not of much difficulty. He noted that the Constitution did place certain limits on state governments and what they could and could not do, and when they did so, they did it explicitly, like in Article 1, Section 10 of the Constitution. To understand the Barron decision and the current reception of the plaintiff's case, the historical context is worth mentioning. The United States was in the middle of the nullification crisis, when then sitting Vice President John C. Calhoun resigned his seat to become a South Carolina senator and challenged the Jackson administration over the state's right to override a federal tariff. In the Barron decision, Marshall gave a resounding win to states' rights advocates and extended an olive branch to help try to keep the Union together. Further, the decision was particularly helpful for the federal judiciary because it allowed it to steer clear of the thorniest legal issue of the time, slavery, which was propped up by state laws muzzling dissent and imprisoning abolitionists. The most enduring result of the Barron versus Baltimore decision is perhaps the court's embrace of what's called legal positivism. This is in contrast to the natural law perspective, and it states that valid legal rights are those that are expressly written down and can be formally cited, rather than abstract universal principles. The Bill of Rights was eventually extended to apply to state governments under the positivist tradition, but that was only after the passage of the 14th Amendment to the Constitution. We'll talk about that next week. As always, thanks so much for watching, and if you enjoyed this video, don't hesitate to give it a like or even subscribe to my channel if you want to see more content like this in the future. See you next week.